Hi everyone, I'm Johnny Roven, Los Angeles personal injury attorney, and today I'm going to be discussing with you slip and fall cases and why they may be more difficult than, let's say, rear ender cases. So essentially, in a slip and fall case, like all other personal injury cases, you have to prove liability. How do you prove liability? Well, in slip and fall cases, a lot of the times you need to prove that the property owner or business had adequate notice of a dangerous condition which ultimately led to the fall. So for example, let's say you walk into a restaurant and a patron drops a glass of water right before you walk in front of it, and then you slip on that puddle, causing a lot of injury. Is the property owner or business going to be liable for that? Probably not, because they had virtually no notice of this dangerous condition on their property. But let's say this patron spills this glass of water 5 minutes before you walk in, and then you have waitresses jumping over it, saying to each other, wow, someone really should clean this up, then they potentially would be liable for that, for your injuries after you slip on that puddle. Really what it comes down to is notice a lot of the time. Did the property owner or business have adequate notice of this dangerous condition? And that's why a lot of these cases get turned away by personal injury attorneys, because there isn't adequate notice a lot of the time. People just have freak accidents, and there's going to be virtually no way to prove liability against the business owner or the property owner. And that's why it's so tough to litigate a lot of these cases. On top of this notice idea, these cases can be very expensive to litigate, because the personal injury attorney may decide that an expert should be used in order to define or in order to evaluate how slippery the floor was. Could it have caused the fall? Was it below a certain standard of care for the restaurant or other business to not clean up the puddle? How long is too long to have adequate notice? There are different factors that fall into that, and also there's different facts that can kind of mess up the liability. For instance, if the waitress saw this puddle and then ran over to go and get a mop and a person slips in the interim, is the restaurant going to be liable in that kind of circumstance? These types of factors can affect the liability. It's not really a matter, yes, there needs to be a decent injury for slip and fall cases in order for it to be worth litigating in superior court, arguably. But more of, was the business owner, property owner, controller liable and negligent for the conduct ultimately causing the injury? That's essentially why it's so difficult to take on a lot of these slip and fall cases. I remember we had a case recently where a woman was walking at night through a hotel, and they were walking on an outside pathway, her and her boyfriend, and the hotel had just finished doing some remodeling on the area, and as they were walking, there was a step that was essentially dark, and the step looked exactly like the step down below. So we filed a lawsuit. So they were walking, she didn't see the step, she fell and suffered severe injuries to her knee and her head, and we filed a lawsuit. And so we contacted an expert, and the expert said to us, this step looks very familiar. It turns out that several years prior, another person slipped on that very same step. And so we were able to show to the hotel that they did have adequate notice of this dangerous condition. They failed to do anything about it. In fact, when the person slipped the first time, there was a metallic strip on the staircase. But this time, after the remodel, there was nothing there. So it was just completely blended in, the top step and the bottom step. So a person really couldn't see it. And this ultimately caused our clients severe injuries. So essentially, this is the type of evidence that is very helpful. You don't always need a prior accident in order to show negligence, but it certainly does help. And that's why, when a person has a slip and fall case, they really could use the help of legal counsel, because an attorney's job is going to be to show where the liability is. You can show what your injuries are, but it's going to be very difficult for a person by themselves to show why the business owner, property owner, controller are going to be liable for the injuries. I hope that this video is helpful. Please contact me with any questions that you have, and you can give me a call anytime, 888-7-JOHNNY7. Thanks so much.